This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why only people who are insureds are entitled to defense or indemnity from an insurance policy. When the representatives of 5 dead pedestrians sought to hold the owner of a vehicle's insurer responsible for the deaths and injuries, the insurer moved for summary judgment, claiming its policy did not apply. In Motorists Commercial Mutual Insurance Company versus Roger Hartwell, Lynnway Auto Auction, Inc., Safety Insurance Company, et al., a November 23, 2022 decision of the United States Court of Appeal for the First Circuit, the plaintiffs claimed they neither owed defense nor indemnity to persons not insured to claims that a vehicle the named insureds owned while driven by the employee of an auctioneer who killed 5 people and injured many more. The dispute arose from an auction at which a motor vehicle, being displayed for bidding, suddenly accelerated into a group of attendees, killing 5 and injuring many others. Motorists, which insured the dealership that owned the vehicle, sued, seeking a declaration that its policies do not cover the auctioneer or its employee who was behind the wheel of the vehicle when it struck the victims. Defendants include those who claim an interest in motorist coverage, the victims, the auctioneer, and its employee. Both sides moved for summary judgment, and the district court granted summary judgment in favor of motorists. Nashua Automotive LLC is a New Hampshire car dealership that sells new and used cars. It is owned by a dealership group called Autofair Inc. and operates under the name Autofair Volkswagen of Nashua, referred to hereafter as Nashua. While Nashua sells most of their vehicles retail to the public, about 8 or 9% of their revenue come from the vehicles sold wholesale, online, or at an auction. For its vehicles sold wholesale, Nashua primarily engages with a company called Lynnway Auto Auction, which operates an auction facility in Barica, Massachusetts. Neither Autofair nor Nashua owns Lynnway, and Lynnway does not own Nashua or Autofair. In April of 2017, Nashua received a 2006 Jeep Grand Cherokee as a trade-in for a new vehicle it sold. Nashua arranged for Lynnway to auction the Jeep. On May 3, 2017, while that Jeep was being put up for auction inside Lynnway Billiker facility, it accelerated into a crowd, causing multiple serious injuries and 5 deaths. At the time of the accident, Lynnway employee Roger Hartwell was seated in the driver's seat of the Jeep. Though he claims that the vehicle accelerated uncontrollably despite his efforts to stop it, he also had a record of having his license removed. In due course, the victims and their estates filed a series of lawsuits in Massachusetts State Court, alleging several theories of liability against Lynnway, Hartwell, Nashua, Autofair, as well as other related individuals and entities. Of the various insurance companies whose policies may be implicated by those underlying claims, this case concerned only one, Motorists Commercial Mutual Insurance Company. Motorists provided a liability policy, the primary policy, that covered Autofair, Nashua, and other Autofair affiliated dealerships as named insureds, but did not name Lynnway or Hartwell among the insureds. Motorists also provided a so-called commercial umbrella policy, which provided supplemental insurance above the primary policy's limits to many of the same insureds, including Nashua and Autofair. The primary policy includes a garage coverage form. This form was modified by a New Hampshire changes in policy endorsement. The New Hampshire endorsement changed the definition of who is an insured, such that it includes, quote, anyone else while using with your permission a covered auto you own, except someone using a covered auto while he or she is working in a business of selling, servicing, or repairing autos, unless the business is yours. The umbrella policy, in turn, provided further coverage for bodily injuries, but contains an automobile liability following form endorsement, which provides, quote, except as coverage is available to you in the underlying policies as set forth in the schedule of underlying insurance, this policy does not apply to the ownership, maintenance, or use of any automobile while away from premises owned by, rented to, or controlled by you. The umbrella policy also defines, quote, who is an insured, close quote, for that policy, which specifically excludes, quote, any person employed by or engaged in the duties of an auto sales agency that you do not operate, close quote. Motorists sought a declaratory judgment that its policies do not provide coverage for the victim's claims against Lynnway and its employee. Defendants include Lynnway and Hartwell, the Lynnway defendants, and the accident victims who brought the state court suits. All defendants moved for summary judgment below, prompting a cross motion from Motorists. Motorists pointed to both the auto business exclusion and a suspended license exclusion, each of which Motorists contended foreclosed coverage under the primary policy. It also argued that its umbrella policies following form endorsement provides auto coverage that is no broader than that provided for in the primary policy. The district court agreed with Motorists on all three scores, granting summary judgment in its favor. The First Circuit, in its analysis, realized that it is axiomatic that interpretation of an insurance policy is a question of law. An appellate court starts its analysis by examining the plain and ordinary meaning of the words in context to construe the policy's terms as would be a reasonable person in the position of the insured based on more than a casual reading of the policy as a whole. On appeal, both Lynnway defendants and the victim defendants contended that the coverage provided by the broad insuring clause of the primary policy survived that policy's auto business exclusion, as well as its suspended license exclusion. They also insisted that the umbrella policy separately provides coverage. The parties agreed that Lynnway and Hartwell are covered under the primary policy unless one of the two exclusions relied upon by Motorists applied. As modified by the New Hampshire endorsement, the exclusion excepts from the definition of insured someone using a covered auto while he or she is working in a business of selling, servicing, or repairing autos, unless that business is yours. The yours in this language refers to a named insured, in this case Nashua. Lynnway's articles of incorporation describe it as a general automobile auction business whose purpose is to auction, sell, and distribute automobiles and to engage in the business of purchasing and selling all types of new and used automobiles. Clearly a business in the operation of the sale of automobiles. Any reasonable person, the First Circuit concluded, understands that an auction is a sale. Thus, someone engaged in an auction business is engaged in a selling business. The language at issue plainly aims at making sure that coverage does not extend in general to persons or entities working in any business of selling autos while at the same time carving out an exception. The issue posed here, in this case, to the First Circuit is the reach of that exception. Clearly, it preserves coverage for Nashua and its employees, construing the business that is yours to mean Nashua's business enterprise, that is, its dealership that sells auto, fully accomplishes this aim. No reasonable insured that procured the policy would ordinarily have any interest in paying for a policy that provided coverage for another person who works for another unrelated seller of autos. Lynnway retained its own insurance policies, the providers of which have conceded the availability of coverage. The fact that Hartwell was employed by and subject to the control of Lynnway reinforces the conclusion that he was not working in Nashua's business. The First Circuit concluded, therefore, that the primary policy's auto business exclusion defines the policies insured so as to exclude Lynnway and Hartwell from coverage for the underlying claims. The defendants next contended that the umbrella policy provides coverage for the underlying claims. However, the phrase follow form refers to the practice common in excess policies of having the second layer coverage follow substantially the primary layer provided by the main insurer. Given that the underlying primary policy does not cover the claimed liabilities, neither does the umbrella policy, and the judgment of the district court was affirmed by the First Circuit. In my opinion, the 5 deaths and multiple injuries prompted reasonably a search for every possible insurance coverage to allow the availability of sufficient funds to indemnify the victims of the runaway Jeep. The attempt was understandable. The arguments were not. The First Circuit read the entire policy, applied the facts of the accident and the relationships of the persons involved, and necessarily found that the motorist policies provided no coverage for the auctioneer and the driver of the Jeep. The analysis was clear, logical, and implied the clear and unambiguous meaning of the policy and its exceptions. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You may subscribe to the blog and you will be notified by email about each new blog postings, usually done at least one every 5 days of every week. And you can also subscribe to the videos on rumble.com, which has more than 550 videos, and youtube.com. And if you view these videos and like to tell your friends and colleagues about the blog and about the videos so that they can also subscribe. And finally, you should consider subscribing to my Substack publications and to my locals community. Thank you for your attention.